The non-residential proof has been placed on record, which has been issued by the competent authority at Bahrain, which would qualify the respondent to be an NRI who had been residing abroad temporarily for employment and would fall under the definition of Section 2D, and in view of the averments made that he has returned to India to do business and to set up his sons also. The bona fide requirement had been made out, and thus the necessary ingredient stood proved. The question of another building being in possession would not stand in the way of the respondent, as the right under the Act is in respect of one residential building or one scheduled building and or non-residential building, each chosen by him under Section 13b(2), and it has been specifically averred by him that the other building is a residential building and not suitable for commercial purposes of setting up the cycle industry as pleaded, since under the Act the owner can take possession of one residential building or one scheduled and or non-residential building, and it is settled law that it is not for the tenant to dictate as to which is the building which is suitable to the landlord for his bona fide need. Reference can be made to the judgment of the Apex Court in Sarla Ahuja versus United India Assurance Company 1998 SCC 119. Relevant portion of the judgment read as under. The crux of the ground envisaged in Clause E of Section 14 of the Act is that the requirement of the landlord for occupation of the tenanted premises must be bona fide. When a landlord asserts that he requires his building for his own occupation, the rent controller shall not proceed on the presumption that the requirement is not bona fide. When other conditions of the clause are satisfied, and when the landlord shows a prima facie case, it is open to the rent controller to draw a presumption that the requirement of the landlord in bona fide. It is often said by the courts that it is not for the tenant to dictate terms to the landlord as to how else he can adjust himself without getting possession of the tenanted premises. In the same circumstances, this court has held that the statement made by learned counsel for the plaintiff has to be read as a whole, and the same would not be split up into two parts, that is, permission to withdraw the suit by but without adverting to the other request of plaintiff for permission to file a fresh suit for same cause of action.